Today we're going to talk about the 14th Amendment. The 14th Amendment to the Constitution was ratified on July 9, 1868, and granted citizenship to all persons born or naturalized in the United States, which include former slaves recently freed. In addition, it forbids states from denying any person life, liberty, or property without due process of law, or to deny any person within its jurisdiction the equal protection of the laws. By directly mentioning the role of the states, the 14th Amendment greatly expanded the protection of civil rights to all Americans, and is cited in more litigation than any other amendment in the United States of America.
A significant case to the 14th Amendment is Loving versus Virginia. By 1967, 16 states had still not repealed their anti-misogyny laws that forbid interracial marriages. Mildred and Richard Loving were residents of one such state, Virginia, who had fallen in love and wanted to get married. Under Virginia's laws, however, Richard, a white man, could not marry Mildred, a woman of African American and Native American descent. The two traveled to Washington, D.C., where they could be married, but they were arrested by state law which prohibited interracial marriage. Because their offense was a criminal conviction, after being found guilty, they were given a prison sentence of 1 year. The trial judge suspended the sentence for 25 years on the condition that the couple leave Virginia. On appeal, the Supreme Court of Appeals of Virginia ruled that the state had an interest in preserving the racial integrity of its constituents, and that because the punishment applied equally to both races, the statute did not violate the Equal Protection Clause of the 14th Amendment. The United States Supreme Court, in a unanimous decision, reversed the Virginia court's ruling and held that the Equal Protection Clause required strict scrutiny to apply to all race-based classifications. Furthermore, the court concluded that the law was rooted in invidious racial discrimination, making it impossible to satisfy compelling government interest. The Loving decision still stands as a milestone in the civil rights movement. And another significant case to the 14th Amendment is Regents of the University of California versus Bach. Alan Bach, a white man, had been denied access to the University of California Medical School at Davis on 2 separate occasions. The medical school set aside 16 spots for minority candidates in an attempt to address unfair minority exclusion from medical school. All 16 candidates from both years had test scores lower than Bach's, but gained access. Bach tested that his exclusion from the medical school was entirely the result of race. The Supreme Court ruled in a severely fractured plurality that the university's use of strict racial quotas was unconstitutional and ordered that the medical school admit Bach, but it also said that race could be used as one of the several factors in the admissions process. Justice Lewis F. Powell, Jr. cast the deciding vote ordering the medical school to admit Bach. However, in his opinion, Powell said that the rigid use of racial quotas violated the Equal Protection Clause of the 14th Amendment.
The 14th Amendment also talks about due process, the regular administration of the law, according to which no citizen may be denied his or her legal rights, and all laws must conform to fundamental accepted legal principles, as the right of the accused to confront his or her accusers. The 14th Amendment implies to all of us living here in America that no matter what race or ethnicity, you have the right to life, liberty, and property, no matter what you do.
Hey, you can't sit there.
Actually, I can. Doesn't matter, you can. Get out of here. Now.